Good evening, dear friends. Today I'm going to discuss about 25 judgments of Supreme Court. It's very important for the upcoming public prosecutor exam of Assam. দেখা গৈছে যে অসমত পাব্লিক প্ৰজিকিউটৰ এক্সাম হ'বলৈ গৈ আছে গতিকে বেসিক্যালি ক্ৰিমিনেল সাইডৰ ওপৰতে কোশ্চেন পেপাৰ অহাৰ পসিবিলিটি আছে দ্যাটস ওয়াই I am making a video on different judgments of Supreme Court which is recently pronounced. Some important judgments I have trying to elaborate in this video. There are 25 judgments available. So let's start the video. First of all, Lolita Kumari versus State of UP, Uttar Pradesh. In that judgment, Honorable Supreme Court pronounced that FIR mandatory in cognizable cases. First information report is mandatory in cognizable cases. Second, Muhammad Ahmad Khan versus Shah Banu Begum. Very historical case. In that case, Honorable Supreme Court said that Section 125 of CRPC is secular. Dharma nirapekho boli koise Section 125 of CRPC. Thereafter, D.K. Basu versus State of West Bengal. Supreme Court guidelines relating to rights of the arrested person. It is seen that police always arrested some suspected or offender person, and sometimes it is alleged that police also misbehaved with such type of arrested persons in the police custody. That's why a case was filed before the Honorable Supreme Court, and title is D.K. Basu versus State of West Bengal. After hearing the case, Honorable Supreme Court pronounced judgment that Supreme Court frames some guidelines or Supreme Court given instructions delivering some guidelines to the rights of the arrested person. গ্ৰেপ্তাৰ হোৱা আসামীবিলাকৰ কিছুমান রাইটস আছে, কিছুমান গাইডলাইন্স। এই সম্পৰ্কত D.K. Basu versus State of West Bengal very important কেছ মনত ৰাখিব লাগিব। Thereafter, Nilabati Behera versus State of Odisha, compensation in case of unlawful arrest and detention. It is frequently seen that some police officer whimsically arrested some unknown and innocent persons. That's why a case was filed before the Honorable Supreme Court, and after hearing the case, Honorable Supreme Court passed judgment, and in that case, Supreme Court held that compensation in case of unlawful arrest and detention, যদি কোনোবা ব্যক্তিক পুলিশে উইদাউট মানে আনলফুলি আৰু উইদাউট এনি ভ্যালিড রিজন যদি গ্রেপ্তার করেছে তেতিয়াহলে কম্পেনসেশন দিয়ার একটা প্রভিজন আছে। জাজমেন্টও আছিল নীলাৱতী বেহেৰা ভাৰ্চেছ ষ্টেট অফ ৱেষ্ট বেংগল, মনত ৰাখিব লাগিব। তাৰপিছত আছে শিলা বাৰ্ছ ভাৰ্চেছ ষ্টেট অফ মহাৰাষ্ট্ৰ, ৰাইটছ অফ উইমেন ৰিলেটিং টু এৰেষ্ট। উইমেনসকলক যেতিয়া এৰেষ্ট কৰা হ'ব সিহঁতৰ কিছুমান ৰাইটছ আছে, এই ৰাইটছবোৰ পুংখানুপুংখভাৱে ডিছকাছ কৰা হৈছে শিলা বাৰ্ছ ভাৰ্চেছ ষ্টেট অফ মহাৰাষ্ট্ৰ। ভেৰি ইম্পৰ্টেণ্ট, এইবোৰ পৰীক্ষাত অহাৰ খুবেই পচিবিলিটি আছে। দেৰফটাৰ আৰু এটা কেছৰ কথা ক'বলৈ ওলাইছোঁ, চানমুনিয়া ভাৰ্চেছ বীৰেন্দ্ৰ কুমাৰ সিং খুশৱাহা। চানমুনিয়া ভাৰ্চেছ বীৰেন্দ্ৰ কুমাৰ সিং খুশৱাহা, রাইট অফ মেইনটেনেন্স ইন লিভ ইন রিলেশনশিপ। বর্তমান সময়ত মানে মেৰিজ হোৱাৰ আগতেই লিভ ইন ৰিলেশ্যনশ্বিপত বসবাস কৰা দেখা যায়, বহুতো ঘটনা বৰ্তমান হৈ আছে। গতিকে কোনোবাই যদি লিভ ইন ৰিলেশ্যনশ্বিপত বসবাস কৰি আছিল, লিভ ইন ৰিলেশ্যনশ্বিপত বসবাস কৰা মহিলাসকলৰ ৰাইট অফ মেইনটেনেন্স খোৰাকি পোৱাৰ হকদাৰ আছে। এই গোচৰৰ জাজমেণ্টটো হৈছে চানমুনিয়া ভাৰ্চেছ বীৰেন্দ্ৰ কুমাৰ সিং খুশৱাহা, মনত ৰাখিব সুপ্ৰিম কোৰ্টৰ জাজমেণ্ট। তাৰপিছত আছে শিৱ শংকৰ সিং ভাৰ্চেছ ষ্টেট অফ বিহাৰ, ফাইলিং মাল্টিপল এফআইআৰ। ইয়াত কিছুমান নিৰ্দেশনা আছে thereafter আহিছোঁ 9th number judgment Satyapal Singh versus State of Madhya Pradesh father of the deceased victim has right to appeal নিশ্চয় বুজি পাইছে victim expired হৈ গ'ল গতিকে victimৰ ফাদাৰে এটা ৰাইট আছে ৰাইট টু appeal কৰাৰ অধিকাৰ আছে এই কথাটো সুপ্ৰিম কোৰ্টে কৈ গ'লে সত্যপাল সিং ভাৰ্চেছ ষ্টেট অফ মধ্য প্ৰদেশ মনত ৰাখিব লাগিব thereafter judgment number 10 state of UP versus Singhara Singh section 164 by the necessary implication prohibits magistrate from giving oral evidence of the confession made to him তাৰপিছত আহিছে judgment number 11 state of Madhya Pradesh versus Rustam computation of period of 60 and 90 days under section 167 of CRPC judgment number 12 CBI versus Anupam J Kulkarni police remand cannot exceed 15 days মনত ৰাখিব police remand cannot exceed 15 days judgment CBI versus Anupam J Kulkarni judgment number 13 Mubarak Ali versus State of Bombay offense triable where act is done very important judgment offense triable where act is done judgment title Mubarak Ali versus State of Bombay judgment number 14 Shakuntala Devi versus State of UP availability of civil remedy does not bar filing of a case under section 200 of CRPC judgment number 15 Dinanath versus Emperor no summary trial in serious or complicated cases summary trial judgment number 16 Surendra Singh versus State of UP where a judge who wrote the judgment dies before it was delivered or pronounced another judge cannot deliver it very important topics title of the judgment is Surendra Singh versus State of Uttar Pradesh Supreme Court held that where a judge who wrote the judgment dies before it was delivered or pronounced another judge cannot deliver it very important citation judgment number 17 Naresh versus State of UP alteration of conviction under section 2302 of IPC to under section 304 IPC by High Court is not justified under section 362 of CRPC judgment number 18 Ashok Kumar versus Union of India constitutional validity of section 433A of CRPC judgment number 19 Rasiklal versus Kishore Khan Chand Wadwani Rasiklal versus Kishore Khan Chand Wadwani right to bail under section 436 is bailable of right to bail under section 436 in bailable offences is an absolute and indefeasible right judgment number 20 Gurbakh Singh Sibia versus State of Punjab Supreme Court guidelines relating to anticipatory bail in the judgment various guidelines is given by the Honorable Supreme Court relating to anticipatory bail in case Gurbakh Singh Sibia versus State of Punjab. Judgment number 21 Jagdish Ram versus State of Rajasthan quashing FIR on account of delay. Judgment number 22 State of Madhya Pradesh versus Madan Lal no compromise in rape cases. No compromise in rape cases. Judgment number 23 Manohar Singh versus State of Rajasthan compensation to victim of crime compensation to victim of crime. Judgment Manohar Singh versus State of Rajasthan. It is seen that in recent times, in case of rape, Honorable Trial Judge has imposed some fine and order to be given in favor of the victim person. Such ruling is flowed different trial court from their judgment is known as Manohar Singh versus State of Rajasthan, where Honorable Supreme Court said that compensation to victim of crime. Judgment number 24, S.R. Sukumar versus Sunnat Raghuram. Amendment in complaint can be done. Amendment in complaint can be done. Last judgment number 25, Siddharth Bashihat versus State and City of Delhi. Cryptic telephonic message of a cognizable offense not to be treated as FIR. In the recent time, it is seen that some messages are delivered through WhatsApp messages, but cryptic telephonic messages of a cognizable offense not to be treated as FIR in case of Siddharth Bashihat versus State of NCT Delhi. So here I have elaborated simply or to the point some important judgment of the Honorable Supreme Court of India. This judgment will be very helpful for your upcoming public prosecutor examination. If you like the video, then don't forget like, comment and share. Thanks a lot. Thanks a lot.